Um, Good morning, everyone. Thank you for joining us. My name's Henrietta Jackson-Stopps, and I run IPOS Mediation alongside my own mediation practice. For those of you who don't know us, we're a panel of 32 mediators with a broad range of experience and skills. We cover almost every type of dispute, from commercial through workplace, public sector, employment, and family, business, and trusts. I believe that what sets us apart as a mediation provider is the quality and expertise of the mediators that we can offer. I've recently added up our collective experience and believe that we have mediated nearly 20,000 cases between us. I'm delighted to be joined today by Rebecca Atree. Rebecca has over 35 years experience in assisting global businesses and individuals to resolve disputes and reach agreements. Prior to becoming a full-time mediator, Rebecca ran her own niche solicitor's practice, specialising in contentious and non-contentious international commercial advice. She's been described as outstanding and hugely impressive, and she's been regularly mediating face-to-face and online well before the pandemic for over a decade, and is recognised by the legal directories for her expertise. We'd like to make this webinar as interactive as is possible, so we will be running some polls during the session, so please do give us some thoughts. It's useful for us to understand the audience we're talking to, given that we can't see you. There will be time for Q&A at the end, so please do put that in the Q&A at the bottom of the screen. Just so that we can get an idea of your collective experience, I will start with the first poll. So please do give us your answers, and I will invite Rebecca to start. Thank you, Rebecca.
Thank you very much indeed, Henrietta, for the warm introduction, and welcome everyone to this webinar. I'm absolutely delighted to be talking about enforcing judgments, awards and mediated settlement agreements post-Brexit. Lots to talk about. This talk is basically about finding effective outcomes to disputes, something that really drives me as a mediator to make sure that whatever deal people make on the mediation day with my help is actually going to have teeth and is actually going to have a result for them. And I'd like to do so particularly in an international context, because international work has been something that has kept me busy, as Henrietta has said, for about the last 35 years. I think people are probably replying to the poll as I'm talking. I don't know whether, Henrietta, you want to launch the other one in a moment, but I'll leave you to launch as we're going. Thank you. Thank you very much. And just to say as well that this webinar is being recorded, so that if others later want to hear, then they can. So in order to take you through this, what I would like to do is to take you on a journey. And it may be the furthest that you've travelled so far this year. Yes, we are in a pandemic, so it's going to be a virtual reality flight for you to take. So do please join me on this journey. And our itinerary is here. We're going to be going from London to Brussels, to Lugano, Hague, New York, and finally landing in Singapore. All this in the space of about the next 30 minutes, 35 minutes or so. Now, some of you who are involved in private international law may be saying, Rebecca, why not Rome? Yeah, I know. I love Rome. Rome is one of my favorite cities. I speak Italian, so any opportunity to go to Rome would have been great. But actually, we don't need to go there today, because those of you familiar with the Rome regulation that deals with choice of law may know that Brexit didn't really touch it. It's one of the few things that Brexit didn't really change. And today is all about jurisdiction, enforcement of court decisions and arbitral awards and mediated settlement agreements. So we're not looking at choice of law today. So here's our itinerary. Fasten your seatbelts, ladies and gentlemen. Let's go off on our first hop of our leg to Brussels. And what I'd like to look at in this talk is enforcing judgments, secondly, arbitral awards, and thirdly, mediated settlement agreements. And I'd like to focus to start with on enforcing judgments, moving through to show really how enforcing arbitral awards is still pretty straightforward, and then coming on to what me as a mediator really lights my fire of enforcing mediated settlement agreements and what hope is there for things to improve on that score. Lots to say. So let's just begin with, why is enforcement so important? So basically, it's to avoid a Pyrrhic victory. So let's just chat through, your client has received a court judgment, an arbitral award, agreed a mediated settlement agreement with someone from IPOS in their favour here in England. The other party has the means to pay. They've said so at court and in the mediation, but they refuse to do so. If it's a court judgment, then enforcement is going to involve seizing and realising the assets of that party in order to meet that judgment, award or agreement. But what happens if their assets are actually outside the original jurisdiction? You need to go off to those different countries to see if you can seize and realise those assets, and will those other courts respect what has happened here in England? And if they don't, you could have a Pyrrhic victory. Now, often people who are mediators say, people want their day in court. They want to be told they're right. Yes, they may do, but actually, usually they also want a result. Usually being told that they're right is not enough. So they need to move on and to actually get full redress. Of course, if you're dealing with aviation or shipping and you have security over those assets from the outset, then no problem, you can enforce that security. But that's only particularly in shipping and aviation and other large movable goods. So let's go on our journey with regard to looking at enforcing court judgments. And our first leg is, off we go to Brussels and Lugano. Well, why are we going there? We don't actually need to stop very long in Brussels and Lugano, because most of what was helpful there has been extinguished by Brexit. Brexit really did mean Brexit when it came to recognition and enforcement of judgments, because we've here in the UK implemented these EU exit regs, which basically revoked the Brussels and the Lugano regimes from a UK perspective. Those previous regimes said if you had a judgment given by an EU or an EEA court, that would be good to go throughout the EU or the EEA. That all went away as a result of these EU exit regulations. However, little bit of hope for those of you who still have cases that are ongoing that you started off last year. The transitional arrangements are there to preserve cases that were ongoing as at 31st of December, 11 o'clock GMT last year. Now, I say that there's a word about Lugano that I'll come back to, but that's the big picture. So Brussels and Lugano gone away. So we need to go to see what is going to happen in terms of what we can do in terms of looking for enforcement. And to do that, we need to go on our next flight to The Hague. So here we are, landed in The Hague, nice, bright, sunny day. And what do we find here? Well, there is some hope from The Hague. I mean, to be honest with you, there have been a number of international Hague Conventions during my time as a professional lawyer and mediator. And to be really honest, they haven't actually really been used very much. Some of you may remember the Hague Uniform Convention on International Sales. There was the Hague Convention on Jurisdiction. Lots of fun and excitement when they were launched, but actually they were little used. So let's see whether this actually 2005 Hague Convention on choice of court agreements is going to find more favour. And I think it probably will. I'm quite optimistic about this 2005 Hague Convention. Now, those of you who think, oh, I rather missed something here, it did actually come into force in the UK on the 1st of October 2015. But most of us, it rather passed us by because we were living quite happily with Brussels and Lugano, and that was what we were relying on. So we didn't need to turn to this. So Hague has been brought and given the force of law by our legislation. I've put this legislation up on the slide here, and this came into force again on the 1st of January of this year. So we've got 2 dates going on, and this is what's the interesting point to bear in mind in terms of how does this go forward, because as any good mediator will know, it's all very well for one person or party or country to say, this is what works for us, but it's necessary then to look at it from the other side and see, is it working for you as well? Those of you who followed the negotiations with regard to Brexit will probably find no surprise when I share my next slide with you that says the EU doesn't agree with us when it comes to this. And they say, no, the Hague Convention only begins in the UK from the 1st of January this year. They say, look, the UK joined the Hague as a part of the EU back in 2015. You didn't do it in your own right. You only did it in your own right, the UK, from the 1st of January this year. Therefore, that is when the relevant date is. Now, I say that the EU says this. Where does it say this? Well, it's in a minute. It's in a minute from the EU Commission. It's as precise as that. There is no legislation. This is just a view at the moment. And they've also published, the EU have published a guidance on how will an EU member state look at an exclusive court jurisdiction clause pointing to the UK. It's complicated, deeply complicated. If any of you are coming from EU countries with experience in that area, love to hear your view on the chat or in the Q&A. But my take from what I've looked at, obviously I didn't have time to research 27 countries for this webinar, but it seems to be that it is quite country specific. But fundamentally, the bottom line is that if someone begins a case in an EU member state that has an English court exclusive jurisdiction clause, an EU member state is not that likely to decline in favour of the UK court, fundamentally because they are still all within the Brussels regime themselves. The Brussels regime is only stopped from the point of view of the UK. So if you're looking at something today and we are after the 1st of January 2021, good news, you don't need to worry about this foible. If on the other hand, you're looking at a case that is relating to a contract that was entered into between 2015 and this year, you are in that slightly nomad land. And I'd like just to give you a takeaway for the commercial departments of those of you attending from law firms, a word for your commercial colleagues, commercial lawyer colleagues, maybe to think about saying to clients to enter into a supplemental agreement, a supplemental amendment to existing contracts to say, we now agree to exclusive courts of England and Wales, because then you've got an agreement on that jurisdiction point that is effective now and comes definitely within the date. Now, as a mediator, I know that asking anybody to agree something when they're already in dispute just isn't going to work unless you come to a mediation. Therefore, that's not going to work if you're looking at a dispute. But in terms of just getting your commercial contract filing cabinet up to date and tickety-boo, that is, I think, something to consider. So that's where we are with looking at enforcement of judgments and looking at Hague Convention. What's the bottom line of this? Well, basically, if you've got a new case in England and Wales and it's initiated on or after 1st of January, we look at, does the Hague Convention on choice of court agreements apply? Yes, if the judgment arises from exclusive jurisdiction. And by the way, on that, it has to be a genuine exclusive jurisdiction clause, what we call vanilla. I love that expression. I'll return to the theme of ice cream and food a little bit later, but a vanilla clause is what you need. And by that, I mean it has to be genuinely mutual and reciprocal. We can't have any of these unilateral or asymmetric clauses, which there may be time to go into later. But basically, Hague says none of that. It's got to be a vanilla clause for it to work. And then if the chosen court is in a contracting party to the Hague Convention. So the question I'm sensing you're all asking is, well, which countries are have actually signed up to the Hague Convention 2005. So the answer is Denmark, the EU excluding Denmark because they did it in their own right, the UK with that question mark on timing, Mexico, Montenegro, and Singapore at the moment. And if you come within all of that and you've got a tick in the box, then the resulting English judgment is going to be enforceable in the EU and the other Hague contracting states under the Hague Convention. So if you have a multinational defendant, assets scattered in those countries, you are going to be able to go off and enforce well, and good luck with that. I did mention about Lugano, just to tell you a little tweak on that Lugano issue. Basically, we didn't deal with Lugano in the withdrawal agreement. So we've got a separate statutory instrument, which from a UK perspective says, yep, Lugano is going to carry on. But guess what? The other countries in Lugano, other than Norway, haven't made any comment on that. So if you're in Switzerland, Iceland, or Norway, the question is quite uncertain. So a lot to look at, a lot of different countries, a lot of different thoughts. What if you're outside of Hague Convention? Then you're into my spaghetti bowl. There you have a diagram of the bilateral treaties between different countries around the world. It's slightly schematic. It might not be 100% up to date. So a little disclaimer on that, but you get the idea. So basically, if you have a non-exclusive jurisdiction clause, or the country hasn't signed up to Hague, then you're into the former pre-Brussels Convention situations. That's pre-1968. I was probably putting on my school uniform for primary school, my first day at primary school then. I mean, that's how far we're going to be going back with that. And basically, we need to look at, is there a bilateral agreement in place, and what would the local country do about it? And the answer is, if there is a bilateral agreement, they probably will enforce, but it's going to be more complicated. You may have to take first direct action on the judgment and then go from there. And then you've got issues of, will they enforce because of public policy and all these different things. But just to let you know, there are bilateral agreements in force between the UK with Austria, Belgium, France, Italy, Germany, Norway, and the Netherlands. So there are some already there to be used. What does this mean in practice for a cross-border contract or subsequent dispute resolution strategy? What's your favorite court? All those forum shopping ideas that we've spoken about. I'm sure private international lawyers for years and years. Can somebody just ignore a decision? But I think, get it right from the get-go. Have an exclusive jurisdiction clause selecting your favoured jurisdiction. And I would also add at this point the old adage, he or she whose course is just is blessed. He or she who gets their blow in first is twice blessed. And so striking first and beginning proceedings in the country of your choice is going to take you a long way from a practical point of view. But as a mediator, I would say, think for a moment, should you mediate before you begin proceedings? That's a discussion for another day, but those are things to think about. And also the issue of, are you actually going to delay proceedings in other countries and play the Limitation Act strategy of beginning a case in one country, and by the time that court has decided have they got jurisdiction or not, time has expired all around the world in the other countries where you might have been able to sue. And that's certainly something I saw quite a lot out of when I was working in litigation as a solicitor. So I think we've probably loitered in Hague long enough. The next flight is being called. We need to board and move on, please, to possibly Lugano. We have an option. Shall we have a detour off to Lugano? What awaits us there? Well, it's a quick and fast ready meal. It's something that we can just quick grab and go. It's an oven ready opportunity, the Lugano Convention. Something that is sitting there that as a UK jurisdiction, we have applied to rejoin Lugano. We actually did that on 8th of April last year. But surprise, surprise, we're waiting for an answer. So far, Norway, Iceland and Switzerland have been good enough to specifically agree to us rejoining, but we need unanimity. And so far, we haven't had an answer from the EU or Denmark. If we did rejoin Lugano, then we'd have a similar position to the Brussels regime, and we can recognise and enforce throughout the EEA. And from my point of view, as someone involved in international dispute resolution, I can only say that I live in hope of that. There is some optimism. The UK government has already got a private international law bill going through Parliament that is all ready to enact if we get the yes from Lugano. And I wait with excitement to see whether that's going to happen. So we are ready to accept and join the club just as soon as we are admitted. But in the meantime, we haven't been admitted, so I don't think we'll stop long in Lugano. We've just had a little drop in there. What we need to do, ladies and gentlemen, is fasten our seatbelts and get on the long-haul flight over to New York. Here we are, where there is a lot of hope and optimism because of the New York Convention, 1958, well established on enforcing arbitral awards. I'm sure this is going to be familiar to many of you. So here, well ratified by many, many countries, very successful, basically gives you the opportunity to recognize and enforce an arbitral award in one of the many countries, 166, sorry, that have ratified. So this is now moving on to my second point, and these last 2 points are shorter. So in terms of where are we likely to see things, I think people are more likely to have submission to arbitration clauses and to use arbitration going forward, because you have got this much more streamlined approach than everything that I've had to talk about before with regard to the courts internationally. And remember that from a UK perspective, the courts are pretty keen just to leave people to get on with their arbitrations and not to intervene. There's the case that I've put up here, which actually many commercial drafts people got excited about, saying may means must, but I always say no, it needs to be taken in the context where somebody had a submission to arbitration where it actually said the parties may arbitrate. And one of the parties went to court and said, here we are, please hear our claim. And the judge said, no, go away. Look at this submission clause. It says you may arbitrate, therefore go arbitrate. And some people said, that means may means must, we must change all our drafting. I don't believe it does, but I think it's in the context of the court's willingness to intervene in what's going on with arbitration. And I think the other takeaway from arbitration is it is usually a one-stop shop. So when you've got your arbitral award, it's pretty difficult to challenge an arbitral award in the courts. I used to deliver a module at a law school on this very topic, but actually decided after running it a few times that it was a pretty recherche point of law and little used. So the good thing about arbitration is you are getting a one-stop shop. And as a mediator, that's what I'm wanting to do, is to help people find closure so that companies can move on and get on to their next projects. So arbitration, good. If there's time, we might have a word about MedArb. We'll see how we go. But that's a hybrid of mediation and arbitration. So final destination. Let's move on to Singapore. There are actually strong family links in my family to the founder of Singapore, Sir Stamford Raffles. So I feel I've truly landed here and found comfort and joy and a homecoming here. And as a mediator, I also feel that because of the Singapore Mediation Convention that I'll tell you about. So this is now my third topic. I've talked about enforcement of court judgments. I've talked about arbitral awards. I'm now moving on to mediated settlement agreements. And what's going on here? Well, basically, a quick recap on what happened in the UK and the EU. We did have an EU Mediation Directive. That's all gone away with Brexit. That allowed for mutual recognition and enforcement of mediated settlement agreements within the EU if they were of a European nature. But the UK decided not to keep that following Brexit because they wanted the same provisions to apply for the EU and domestic mediations. So we're back to our UK approach that you need a Tomlin order, of course, if you're going to get enforceability in England and Wales. And beyond that, in terms of enforcement of a mediated settlement agreement, the position is less strong, but there are new things that are coming that are going to give greater teeth to mediated settlement agreements by way of the Singapore Convention, why we have landed in Singapore. So we have, as many of you may have come across, the UN Singapore Convention on Mediation. Massive take-up, 53 countries signed it, but actually in order for it to come into force, it needed to be ratified. And although important countries such as US, China, India, Malaysia, the Philippines, Singapore and South Korea did sign it, notably not the UK, the EU or Australia, actually currently it's only in force with those countries at the bottom of my slide: Singapore, Fiji, Qatar, Saudi Arabia, Ecuador and Belarus. So great that those countries have seized this opportunity. Hope that many of those other countries will do so. But it doesn't mean to say it's something we should ignore because it's not enforceable in many countries. Firstly, because it raises the profile of international mediation. It's a very important piece of legislation, and the fact that we've got international legislation on mediation, I think, is super important. But beyond that, it can actually apply today. It can apply to me sitting there in the offices that I often use to mediate when we can do it in person there by Tower Bridge. It can apply, the Singapore Convention can apply where at least two parties mediate, and the place where the settlement agreement is to be performed or where the subject matter of the settlement agreement is most closely connected is in a state that signed the convention, then it can apply, because it doesn't, the whole thing about the Singapore Convention is it doesn't rely on reciprocity. It's not like the New York Convention in that way. So mediations I've done, such as relating to beer kegs in Russia, penny sweets in Belgium, don't ask, there were millions of them and they were all melting in the summer, or ice cream and wine in Sicily, much more to my taste. Those mediations potentially, if they were to happen today, if those countries had signed up to the Singapore Convention, the Singapore Convention would be applying. And basically, the Singapore Convention says, if it applies, then the mediated settlement agreement can be enforced in those relevant countries. And that's something, I've mentioned agreements having teeth and judgments and awards and settlement agreements having teeth. I think that is so important as a mediator. If I get a whiff at a mediation that someone is actually not really signing up to what they say they'll do, I'm on it, and I am probing and I am reality testing. And I may then suggest, well, if that's not really feeling comfortable with you, why don't you suggest what you can actually do? I mean, I even had a mediation recently where the party said to the barrister in front of me, yeah, we can agree to pay X million by a given date. And then they looked at the barrister and said, if we actually don't want to do that, how long can we delay that for? How much can we wriggle out of that? And that was an uncomfortable moment for me. And I said, shall we just stop there? And can you just share with me what actually is a realistic timescale for you? And I propose that, you know, you build that into your offer that you're making, because it's very important that what anybody agrees to at a mediation is something that they will follow through. But research has shown that people are more likely to actually do what they say they'll do at a mediation because they volunteered it. They've thought it through, it's come from them. And they are actually more likely to do it anyway than necessarily needing all of the legislation of enforcement behind them, because that's something that they have actually volunteered and they've agreed to. Many people who go to court are actually dissatisfied with the result, even if they win, because of the cost and time it's taken. But there we are. So time is running out. Would like to just wrap up by one or two quick things. MedArb, the WYSI hybrid model, does that fit into this discussion? Perhaps it does, because if a client wants to have closure and they want to begin a process that they know will have closure at the end of it, They could think about saying, let's have a MEDARB where they come along and actually the mediation agreement is written up as an arbitration award because the mediator is also an arbitrator. This is all quite controversial, and many purists think there's a lot to think about in this process, and I would agree. If it's written up as an arbitral award, can it then take advantage of the whole New York Convention of Enforceability? Or another MEDARB approach is parties say, we'll mediate. If we don't get a settlement, mediator takes off hat of mediator and puts on hat of being arbitrator. Those of you engaged in mediation, I'm sure, will be jumping up and down going, confidentiality, Rebecca? How does that work? Yeah, I completely see that. New South Wales have actually got a procedure that they say overcomes that. I've never fully got into the detail, but I just put it out there that MEDARB is something that, for example, the Singapore Dispute Resolution Centre does embrace, but you know, at what price? Are you actually changing the whole nature of the mediation process? Because if people know that ultimately that independent, neutral person that they're sharing everything with is later going to make a decision, I think that changes the ball game. So it's not something I sign up to, also because I'm not an arbitrator, so I can't. So there we are. If you come to me, you would get a straightforward mediation. But I put that out there for the those involved in dispute resolution. So to summarize, what's new post-Brexit in 2020? I've talked about enforcing judgments. I think it's complicated. The situation is changing rapidly. The law is changing rapidly. You've also got the fact that companies' assets are probably also changing quite rapidly in terms of where are companies setting up and putting their assets at the moment. So you've got a fast-moving field there. Arbitral awards, the situation is clearer. You have a very recognised and established system, and mediated settlement agreements, I believe that they have enforceability because of the nature of mediation, but there is hope coming along in terms of backup convention from Singapore. So I hope you've enjoyed the flight. London, Brussels, Lugano, Hague, New York, Singapore. It's been an exciting journey. My predictions and call to action, my prediction is I think we're likely to see an uptake in exclusive jurisdiction clauses and also submission to arbitration clauses. I think my call to action is to consider mediation, DIY, DR, it's maybe called, you know, do it yourself, because the parties make up their own minds, but they need some good lawyers and advisors along the way as well, of course. It may be that it is likely to be better in achieving a practical, enforceable outcome internationally than trying to come to grips with Hague 2005, trying to come within it, or the spaghetti bowl of treaties, or waiting for the oven-ready enforcement under the Lugano. And I think international mediation is probably going to stay online quite a lot because of the ability to straddle timelines and the cutting down on travel. The environmental carbon footprint is better. But I think when it comes to other disputes, I think we are going to have a resumption of in-person mediations, particularly the kind of mediations that I often do that involve complex matters of issues of trust, rapport and relationship, and you know, really being able to see the whites of the eyes of everyone. I think we will see that coming back. And really what's motivates me as an international mediator is that if we can solve disputes internationally, I hope that that will help to build world peace. And so thank you for listening. I look forward to the questions and discussion. I'll pass over to Hetty, and we do have a final poll to ask before closing. So thank you for your attention.
Thank you, Rebecca. That was really informative. And we do have some questions, which I will put to you now. On the Hague date point, is it enough to sign an amendment dealing with the issue dated this year, or do you need to re-execute the whole the whole contract this year?
That's a really excellent question. Thank you. I think from a contractual point of view, I think it would be sufficient to sign an amendment. Of course, you'd always need to make sure that if the original agreement had been done by a deed, you would need to make it as a deed. You need to make sure that you have it fully legally enforceable. But I think a simple supplemental agreement on the exclusive jurisdiction would be sufficient. But I bow to the views of any other solicitors, barristers on this call, any other views. And that's, of course, from a purely English law perspective. Thank you.
And then we've had one asking about an exclusive jurisdiction clause from Malcolm. I was always told that an exclusive jurisdiction clause prevented an English party claiming against a party outside of the UK. Is that true? And what about a clause which says exclusive English law where you need to enforce in Scotland?
That's a very interesting question too. Thank you. So, by the way, here I'm giving my 2 penneth worth. I'm not giving
legal advice.
But my thought is on that generally, yes, if it's a true vanilla exclusive jurisdiction clause, it will prevent an English party claiming against a party outside of the UK from an English perspective. But if you were to bring a case in the DIFC, the Dubai courts, and kick off there and begin something, and what you were saying rang great bells with the Sharia compliant judges and everything that was being talked about there, I think they might be quite keen to hear it. They may not say, actually, no, we're not going to take jurisdiction here, we're going to send it back to the UK. So from a an English perspective, yes, it does give you, it would prevent you, but who's to say that the courts of the other countries won't, if given an opportunity, give it a try? And then you've also got issues of moreover injunctions and the like, where other countries are pretty keen if you've got a ship in their territorial waters or a plane that's on their jurisdiction, again, that they are quite likely to go, well, it's here and we'll take it. And I like this question about England and Scotland. So often people overlook the difference that, of course, Scotland is a separate jurisdiction. And yes, if it's exclusive English law, then you're into all the rules that I've talked about, because Scotland is a separate jurisdiction. So you would need, I believe, to have it recognised and enforced in Scotland, and you couldn't bring the case in Scotland. But anyone attending from Scotland, I would be interested to hear the Scottish point of view, because I'm very conscious that I'm talking here as an English person. I think the other thing I'd say is there is a pretty old case where there was a submission to the UK jurisdiction and the judge said, fine, I'll hear it. That's okay. That's not a correct submission, but it doesn't matter. I don't have many more cases today, so that's fine. UK jurisdiction is good to go. I hope that answers your question, Malcolm. But of course, we do have to bear in mind the question of exclusive. And is it a true exclusive vanilla jurisdiction clause of the sort that I mentioned earlier? Thank you.
And we've got one from Jeffrey, he was under the impression that the reservation to the New York Convention to reciprocity was not universally taken. Is that wrong?
Thank you. So I'm not quite understanding what is meant by the reservation to the New York Convention. Jeffrey, I don't know if you could put something more on the chat, or Hetty, if you have a...
No, I wondered if it was to do, I don't know, because I was going to ask you a question about the Singapore Convention, actually. And it might be along the similar lines, because I've heard views from senior mediators, experienced international mediators, that they are against the Singapore Convention, because it's their feeling that parties entering into a mediation will be reluctant to do so if on the settlement agreement being signed, that is then immediately enforceable against their assets overseas. And that, in fact, the beauty perhaps of mediation is that is not the case, and that parties can meet their obligations in the ways that under their own control, so to speak. Have you heard that, and what are your thoughts?
That's a really, really interesting point. And I think there is the possibility that there's a reservation that countries signing up to the Singapore Convention, the country can actually say, we'll have this reservation that the parties can decide, will they agree to Singapore applying or not. If I had people coming to a mediation and they were saying, we'll come and have a settlement facilitated by you, Rebecca, but when it comes to enforcement, we don't want to sign up to the letter of the law. Is that actually coming to a mediation in good faith? I wonder. I understand that sometimes people do want to ring fence things, and they may feel this is England, this is ring fence, this is as far as it goes. But so many things now are international. I mean, if you look at data is the new minefield. Data is the big commodity. Where does data reside? If you were actually going to be seizing data, is that jurisdictional? It's not. It's global. So I think that the idea that if people are going to solve things, they're going to see it through, they're going to sign up to the process. Hopefully, it wouldn't need to be enforced against them. But if people are saying not, I think that gives a question mark about where is it really going. But I do understand where some mediators are coming from with that, and they're saying it means we're all subject to international review, because there is the possibility for other courts to look at issues in some detail about what's happened in the mediation in rare cases. But I believe all professionals should be subject to scrutiny, and that's what makes the profession a proper profession.
Yeah, I think I agree with you. Although, I mean, there are some who, of course, say that, how often do we come across a mediated settlement that it isn't, that needs enforcement? How often are they not complied with? And certainly in my practice, it's very rare. And I don't know what in your experience, I suppose as mediators, we don't always hear what happens after the mediation.
That's very true, but I haven't actually ever had a situation where people have come back because it hasn't been seen through. And I think, as I've said, the beauty of mediation is that people are truly signing up to something. Yes, it's a really interesting area, and that concept of voluntary or mandatory and how far does everything go is a fascinating area. But I'd be interested in other people's views on this call, because there are many highly qualified people, I think, who are here. I think we've got some more questions coming in.
We've had an answer to the applicable law and jurisdiction. Would the answer not be that if the jurisdiction is Scotland and the applicable law is English, then it would be a case of a Scottish court hearing the claim but applying English law?
Spot on, Pia. Absolutely. Yes, we always have to be so careful that we differentiate between applicable law on the one hand, my Rome Convention, where we didn't go today, Rome regulation, and then on the other hand, the question of jurisdiction. And I think from memory that Malcolm's question was dealing with exclusive jurisdiction itself. But as Pia has written it on the Q&A, I believe is spot on, 100% correct. Yes, that's right. And that shows the difficulty of bringing court proceedings in another country and applying another law. Highly expensive, and the whole translation costs. I've seen that myself. And how convincing will a witness be if they're not speaking in their own mother tongue? I mean, here, obviously, England and Scotland, that wouldn't be relevant, but certainly in my experience with Italian, French, German speakers, that can be difficult. Thank you.
Interesting point from Christopher Mills, who said that he's done a lot of work for global business where all contracts globally had compulsory mediation and arbitration clauses, jurisdiction England and Wales using the LCIA rules, which mitigated the legal and business risk globally of litigation. And I think that sounds eminently sensible. We don't often see compulsory mediation clauses. I certainly don't. It's usually through parties' choice as opposed to a contractually enforceable mechanism. But do you often see them, Rebecca?
Not as much as I would like. Whenever I get an opportunity, I encourage people to think about that. I think the issue with the mandatory mediation clause is its enforceability, because mediation of itself is voluntary. And so in order, from my understanding of the cases in the last kind of decade, in order for a mandatory mediation submission to work, you actually need to sign up to a body that has a provision that says we will set up the mediation if you don't agree to the voluntary way, and we'll set it up. And if you don't come to it, then you haven't complied, because otherwise there's always the opportunity for somebody to say, no, I don't like the look of Rebecca's sandwiches. I would rather go with another mediator who produces, you know, the full-on buffet. And no, that day doesn't suit me. And so delaying and prevaricating. And have they at any point failed in their agreement to mediate? It's not clear. So that's where signing up, I believe the LCIA provisions do have that mandatory default, that if you can't agree on your party, we will set it up, and either you come to it or you don't. And then we have a clear breach if you don't come to it. But I think the thing that's controversial about that is, where do you put that mandatory mediation process? Do you say you must do it before you litigate or arbitrate? And whereas, yes, I'm a conflict resolver and I love it if we can all get around a table before any proceedings are begun, I know that sometimes the potential defendant may be saying at that point, if no proceedings have been issued, well, what's the case? How can I assess my risk? I don't know really what they're asking for. How serious are they? So it's a strategy whether actually something's begun and then a mediation happens quite soon after. So having a mandatory mediation clause, great, but it does mean that you're going to be in that situation of having to mediate before you go on to the next stage. And it may not be the best moment to do that for a number of reasons.
Yeah, I mean, we do, as IPOS, have a mediation clause that can be put into contracts. And of course, if the parties can't agree, then they can come to us and we can say, well, here's your choice of three. And if you still can't agree between the three, then we'll choose the mediator for you best suited for the dispute. And I think that is one of the benefits of coming to a service provider like ourselves. We can take some of the partiality out of that conversation about who the mediator can be. And we often find ourselves mediating the mediation, as we call it, when parties can't agree on the mediator. We can often provide them with one and both parties accept it. Jeffrey's come back on the NYC New York Convention question, saying that he thinks that the convention has a reservation which allows a state to say it will only enforce if the other country is a signatory, which I think touches upon the same sorts of reservations that we see in the Singapore Convention.
Yeah, indeed, yes, absolutely. I see what he's saying. Yeah. Yes. And I think it hasn't been universally taken. I think that's right, Jeffrey. Thank you for that. It's a good point to make, and it's a further detail to look at. It just shows that behind every bullet point on a slide, there are many more nuances, which is what keeps the lawyers busy. But thank you very much for raising that. It's a very good point. Thank you.
We've had a question from Silvana. In your experience, are mediation clauses nowadays used more than in the past, especially before Brexit?
Yes, I think they are. Silvana, welcome. Good to see you on this call from the University of Trento. I think mediation clauses are used more. Of course, from an English point of view, actually, just a basic agreement to mediate is not enforceable, just like saying we agree to negotiate, because an agreement to agree does not create a contract. So I'm increasingly saying to people, yes, having clauses in contracts which are not 100% enforceable can actually be helpful, because when the chips are down, you can point to that and say, look, we agreed we'd try and negotiate within the next month. And if that doesn't work, we've agreed that we will mediate. And I think they are increasingly so. And I'm seeing more and more cases that come to me as a mediator when I'm looking at the contracts that are the subject of the dispute. I am heartened to see that there are mediation clauses in them.
Thank you. We've got one final question. It's quite specific and might be one that you might want to take up afterwards. But if a dispute relates to a will where the testator died after 2015, but before 2021, but court proceedings are still to be issued, which rules would apply?
Oh, that is a really interesting question. And having tested my brain on all these other things, I have to say I don't know the detailed answer, but there is the whole regime in Europe, in the EU, that the UK hasn't signed up to that relates to wills that I can't remember off the top of my head, but maybe somebody else on this call can remind me and put it on the chat or the Q&A. But that gets super complicated. Also because you may actually find that people have several wills and that the wills will be relating to where the property actually is. I mean, I'm actually an executor, one of my oldest and dearest clients, and it's a UK, I'm the UK estate executor, but then there's a global will for everything in the rest of the world. So you would then have the issue of where would you be beginning the case, and it would depend what kind of case it is. If it was an Inheritance Act family dependence case, then we're looking more at the UK rules. But if it was challenging capacity and other things under the will, then we're onto a wholly different ball game there. I'm sorry not to be able to give a very detailed answer, but those are my initial thoughts. Anyone else who's got any thoughts, I'd be very interested to hear them.
I think that was that was a pretty specific question, and but certainly one, Jan, that if you do have to speak to a lawyer on this, if you're not a lawyer yourself, that you might want to ask about the Hague Convention.
Yeah, actually, I'm just thinking, just very quickly, I think probably Hague Convention doesn't apply, because I'm just thinking it's actually a will, so it's not actually a contract, and I believe that the Hague Convention it certainly doesn't apply to consumer contracts. My sense is it probably wouldn't apply.
Yeah. Okay. Well, thank you. We've gone all the way around the world and come back to wills. Rebecca, that was really useful and informative. Thank you very much for your time today. We at IPOS are doing a number of webinars, so please do keep an eye on our newsletter and sign up to our newsletter or to our events group. You can manage your preferences. We offer bespoke in-house training on a number of topics. We have, as I said at the beginning, a broad range of mediators, and make our topics bespoke to you and your audience and or your clients, because of course it's always useful to educate your clients on mediation if they are regular users. On the slide here are a couple of the topics that we provide. We're currently booking into April and May at the moment. So if you would like some more information on training sessions, and Rebecca or another of our mediators can come in and talk to you, please do get in touch on the email address there, info@mediate.co.uk. Thank you again, Rebecca. Thank you to everybody for joining us. I hope you enjoyed it, and we look forward to seeing you at another webinar in the future. Many thanks.
Thank you. You're very welcome. Have a good rest of the day to everybody. Thank you, Hetty, as well.
Thank you. Bye.
Bye-bye.